Dumas-Mueller?
It's Dumas-Mueller, yep.
Dumas-Mueller. And so if please hold any questions if you can, unless you're calling into the chat. And at the end, we'll have verbal questions. And about quarter of, I'll give a time check thereabouts. And I'll just turn it over to the presenters to do their thing. Thank you.
Well, good morning. Thanks for being here. As you heard, my name is Kim and I'm with my colleague Michelle, and today we're going to talk about veterans discrimination. I am using a PowerPoint that hopefully will be helpful to you. Let's see. Oops. So what is the CHRO? Some of you might wonder. We are Connecticut's oldest civil rights agency, and our mission is to eliminate discrimination through civil and human rights law enforcement and establish equal opportunity for justice of all persons within the state through advocacy and education. It's a really lofty mission that we have. It's sort of like Michelle always says, a Miss America mission, but you know, especially in times that we have right now, where there's so much social unrest, you know, I think it's a really important time for our agency to be doing this kind of work. And we're going to do some advocacy and education this morning and try to educate you about what discrimination is and what it might mean for veterans. So I think my colleagues.
So there are. You had cut out for a sec. Hi. So hi, I'm Michelle. And so, you know, what are the types of cases that we handle at the commission? And so what we do is we handle employment discrimination cases. And what that means is that as an employee, you should be free from engaging in a work that is discriminatory towards you. And that's not only in your work environment, and that can involve requesting accommodations if you're disabled, but it also is if you are not hired for a job or if you are terminated from a job based on discrimination. And we're going to go through all of the protected classes. Discrimination is a big word. It means, you know, making a choice of one over the other. And we want to talk to you about the discrimination that is illegal in our statutes. So we cover employment discrimination. We cover housing and credit discrimination. Housing is its own unit, and we get about 220 housing cases a year. And when we talk about housing, we mean failure to rent, discriminatory eviction, different terms and conditions while you're in housing. You know, maybe you get to park in the back, but people who have children don't get to park their car in the back. Things that are different based on a protected class that you fit into. Credit discrimination, if for some reason one of the protected classes you fit into means you have different access to credit or lack of access to credit, those are cases that we take. We get them very infrequently. And then last is public accommodation, which is a big protected area. And any place that you go to that invites you in is a place of public accommodation. So we're talking about stores and shops and the mall and the grocery store, but we're also talking about schools and police departments and government buildings and our agency, the Commission on Human Rights and Opportunities. Places that serve the public and offer services to the public cannot discriminate against the people who services are being sought. And so those types of cases are also filed with the agency.
So today what we're talking about is legal discrimination. So there's discrimination in our lives every day. This morning I had to decide if I wanted to have eggs for for breakfast or a bowl of cereal, and I decided on the eggs. I prefer the eggs. I made a discriminating decision, or I might like vanilla ice cream rather than strawberry. Those kind of discriminations are just decisions you make every day. But the kind of discrimination we're going to talk about today is illegal discrimination, when you treat people differently based on a protected class basis. We're going to talk about all the protected classes that the Commission covers, but some of them you might think of as someone's race or their age, their religion, or even being a veteran. That itself is a protected class, and we're going to talk a lot about that during this presentation.
So what are the protected classes? There's 27 in Connecticut, so that's a fair amount. You can certainly go onto our website, which is at www.ct.gov/CHRO. That information will be at the end of our training, but it contains all of the information that we're talking about today, just because it can be kind of overwhelming, really. So age in Connecticut is protected, and age is not just 40 and above. So a lot of people think about age discrimination and employment, and that starts at 40. But for us in Connecticut, it is any age that you're being treated differently because of your age. And so while we get a fair amount of cases that are for people who are older and are claiming discrimination based on that older age, we recently, about a year ago, had some cases where a local chain came in and bought some restaurants, and they decided to terminate all of the employees who were under the age of 18. And that would be illegal, because if you are 16 and 17, according to the Department of Labor, you're able to work. And so that's a lower level age protected class. So we're going to talk about alienage. Alienage is where your family comes from. It's not your national origin, which is where you're born, and both are protected. So your national origin is the country you're born in. And so I was born in Hartford, and so my national origin is the United States. But my alienage is Canada. My family on both sides are French Canadian. And they some are from Canada, some are from northern Maine, where there's a lot of French Canadians who live. And so, if someone were to ask me what my ancestry is, it's Canadian national origin. So, breastfeeding is a protected class. That is the right to nurse your child wherever you are. And you cannot be told certain restrictions based on your need to breastfeed your child. And so frequently we'll get cases where people are either told they can't breastfeed in a certain location, or that they need to move so that people don't see them. And so those cases are pretty nuanced, but they are legal activities that people are engaging in. And so it's important that that everyone knows that, because sometimes there's just kind of a lack of knowledge that leads to poor choices being made. Color and criminal record. So when it comes to criminal record, the state of Connecticut, as an employer and as an entity that educates people and gives out licenses to people, like if you're a plumber or a hairdresser, they can't just upfront say that you don't get to work here or you don't get that license because of a criminal record. What they need to do is they need to engage in a balancing test between the duration of time from the conviction, the crime committed, and the job sought or the license sought, and determine whether you are somebody who can be employed because your criminal record doesn't relate to what it is that you're seeking from the state. Criminal record tends to have a disproportionate impact on people who are African American and Hispanic. And color is a protected class, and color is any color of whatever your skin color may be. But the vast majority of cases we get related to color happen to be brought by people who are either African American or darker a darker complected person who is maybe Hispanic or another national origin. And so we take criminal record complaints from private employers, even though that is not a protected class for private employers, because often there's a disproportionate impact on people of color as it relates to a criminal record. Family status is whether you have children under the age of 18, you are pregnant, or you are in the process of adopting a child. And so family status is a housing protected class. And we get, as a matter of fact, I'm just settling a family status case right now where the complainant, the person who brought the complaint, was about to take into her family 2 foster children who were in the DCF system. And the landlord, she had previously had an adult child living with her, but no children under the age of 18. And the landlord was not, he was not really feeling that at all, frankly. So she filed a discrimination complaint because he moved to evict her because of these children being present. So that's a kind of a classic family status case. Failure to accommodate due to a disability. So disability, both in the housing and the employment parts of the work that we do, is the number one protected class. So the most complaints that we get are based on somebody either not being hired because of a disability, being terminated because of a disability, or failing to be accommodated because of the disability. And we're going to talk more about reasonable accommodation later in our presentation, but I just want to put that out there for something for you to think about. Gender identity or expression is a protected class. And what that means is that if your gender identity is different from your birth gender, or your gender expression doesn't conform with any gender, frankly, there's a very long definition in our statute, you cannot be discriminated against either in employment, in state services, and in housing. And so that passed in 2011. And it means that you are allowed to have all access to all things as long as you're qualified, regardless of what your gender identity or expression is. Genetic information is also a protected class. I've never had a complaint. I know there's been a few, but you know how you can have testing done to figure out whether you carry the gene to have certain type of cancers. For women, it's, breast cancer or ovarian cancer. If you have colon cancer, those types of tests exist to kind of give you some tools to make decisions and how you will treat and or live your life, frankly. So if for some reason an employer finds out about your genetic information, say they know you're predisposed to get some certain type of cancer, they can't use that against you. So if they decided, Michelle has this predisposition to this type of cancer, if she gets it, it's going to be really expensive for us. She won't be in. Maybe our insurance rates will go up if we're a small business. We're just kind of hanging on with this. We're just going to let her go right now. And otherwise, they wouldn't, come for me at all, just because they know my genetic information. So we don't get that many complaints on that. But if you feel that's a reason, then you can file a complaint with us and we'll help you figure that out. So guide dogs kind of there's a lot of definitions about guide dogs. What we're talking about for guide dogs is there's under the Americans with Disabilities Act, there's a definition of what a service animal is, and it has to be a dog or a small pony, and it has to provide a service to the person who has the animal. And so a lot of people see that as a CNI dog or a hear and ear dog. But we also have emotional support animals. And those are, they're animals that provide emotional support for somebody who has a mental health condition. And so we'll talk a little bit more about that when we get to reasonable accommodation and disability. But depending on where you are in the public, at your house, in your job, there's some kind of different rules to follow as it relates to that.
There's so many protected classes.
I know.
So we cover all kind of disabilities, not just physical disabilities, but intellectual disabilities, learning disabilities, mental disabilities, any kind of really disability that a person can have, whether that be a mobility impairment, whether that be a heart condition. Connecticut has a very, very broad definition of disability. And unless you have maybe like a hangnail or like the flu, you're going to be covered. There's going to be lots of litigation, I suspect, on whether COVID is a disability. As of now, if you have a COVID-related discrimination case, I'd say call us and file it, and we'll take it and try to sort it out. But disability, yeah, we cover a lot. We have multiple source of income in housing and public accommodations, and we're going to be talking about that a little bit at the end of the training. But basically what that says is if you're getting income from anywhere, it could be from child support, it could be from Section 8, a landlord has to take that income as part of your income for housing. We cover marital status. Are you single? Are you separated? Are you divorced? Michelle talked a little bit about national origin, which is the country that you were born in. This is different than race. Race is very specific, and I always have to look at my cheat sheet. There's categories of race that the Census Bureau puts out, and that is white, black or African American, American Indian or Alaska Native, Asian and Native Hawaiian or other Pacific. Hispanic is not a race. Hispanic is probably a country. Like if you're Hispanic and you're from Spain, if you were born in Spain, your national origin is Spain. If your ancestors were born in Spain, but you were born in the United States, your national origin is United States, your ancestry is Spain. We cover religion, religious creed, so that could be someone who has a religious belief or is an atheist, has no religious belief. And we don't get a ton of those cases, but there are some religious cases we get in terms of people needing accommodations at work. Maybe they can't work on the Sabbath, or they need to have certain days off, or they need time to pray in the middle of the day. That comes up sometimes. Another big category we get is retaliation. So someone files a CHRO complaint, and maybe we don't even find that there's any cause to believe discrimination has taken place, but then right away something bad happens. So maybe they filed a CHRO complaint against their employer saying they were harassed at work. We find there was no harassment, and then as soon as our finding comes out, they're fired. That's an example of retaliation. It could come up in housing too, a landlord filing an eviction as a result of filing a CHRO complaint. And it doesn't necessarily even just have to be a CHRO complaint. If you're complaining to your employer itself about discrimination and something bad happens to you. So we get a lot of retaliation cases. We get sex discrimination cases, and that includes pregnancy, and it also includes lactating mothers. Michelle talked a little bit about the breastfeeding, but so if a woman thinks she didn't get a job because she was female, she can file a case. Someone gets fired because they're pregnant or doesn't get their job back after they come back from maternity leave. These are all cases that we handle. Or if a mother is being given a hard time about breastfeeding at work, she can also file a case with us.
So veteran status is actually the last protected class specifically that was added to our statute. And, certainly we had cases from veterans prior to that, but they tended to use different protected classes, primarily disability, in order to file a complaint with us. Now that isn't necessary. It could be that it's both protected classes, because you're not limited to just filing a complaint and stating one protected class. Often people state many protected classes. It could be gender, race, and color. It could be disability, race, and color. It could be all sorts of things. So veterans as its own protected class is powerful because now it has its own place, and it can be added to the other protected classes that we listed previously. And that veterans protection extends to all of the protected classes that we fit into. And our definition of veterans is from the portion of the statute that speaks to veterans. We didn't create a new definition for veterans, and so our definition is the same as used throughout the Connecticut general statutes. But that protection extends to housing, employment, places of public accommodation, and credit transactions, which are the protected areas that we enforce and receive complaints about.
So here are some examples of discrimination that veterans might face. Refusal to hire a veteran because there's some kind of assumption that they have PTSD and that they might have a short temper. That's something we hear sometimes. Sometimes veterans do have PTSD and sometimes they don't, but a lot of people will make assumptions that anyone who's a wartime veteran would have PTSD and would not be able to handle a stressful situation or a situation that needs someone to remain calm. That's just stereotyping. Refusal to accept veterans as tenants because they perhaps feel that they might not pay the rent or they may not be good tenants for whatever reason.
So here are some signs that as a veteran, you might be discriminated against at work. It may be that your employer tells you that the job's no longer available. A lot of times people know people who are still in the job and know that the job is available, and in fact went to somebody else who's not a veteran. And so at the commission, what we would do is if you filed a complaint with us, we would be able to investigate whether somebody did get your job, whether it was refilled, which happens. And so, so that ends up being really good evidence for your case. They won't hire you when they find out you are a veteran. A lot of times employers have hiring preferences for veterans, but also employers may not want to hire somebody because they're concerned that they're going to leave, especially if you're, say, in the National Guard and you need to go at certain times and it's unpredictable when you are needing to go, or they're just concerned about the disability aspects of what you may or may not bring to the job. And again, kind of like my example before about the genetic information, they may not want to hire you because they're already thinking in their head all of the things that may happen, which are very unlikely to happen. You might be harassed. People may not understand the sacrifices you've made and have opposite opinions about what a veteran is, and so will target you because of whatever their opinions are. And so in your job, even though you were hired and you are working, it could be that the people around you are treating you negatively and in a hostile manner because of your status as a veteran. It may be that you're not hired because of a disability that's related to your service. And so that would be discriminatory. It would be discriminatory to not hire somebody who has a disability and can perform the essential function of the job in general, but kind of lumping on top of that even more requirements because of their, again, incorrect assumptions about your ability to do the job because you're a veteran and you're disabled. A lot of the work that we do and why these protected classes are protected is because of the inappropriate assumptions that people, employers, coworkers, third-party vendors, whoever it is you deal with at work, make about you based on your inclusion in certain protected classes, including veterans. And maybe your boss decides that he or she's not going to give you time off because they believe that your veteran status and your medical condition are intertwined, and that that's something that you have to deal with. They're not going to give you the time off, which again is a problem just on a regular disability level, but certainly a much bigger issue for somebody who's a veteran who may be disabled because of their service. And so, as I said, not everybody, treats veterans in the admirable way that you should be treated for the service and the sacrifice you gave to our country. And it's unfortunate, but it's protected. And we're here to help you make sure that you are not treated negatively because of that.
We talked a little bit about lawful source of income, and I know that many veterans will have had housing subsidies such as the Veterans Affairs Supportive Housing or VASH. And again, it's illegal for a landlord to say, I won't take your subsidy because I only want people who are working, or I only want people who have jobs, or perhaps it's because they don't like veterans for some reason. In Connecticut, the law is very clear. If you have a housing subsidy, it has to be something that landlords accept, just like they would have to accept Section 8 or a RAP certificate or a security deposit guarantee. That's money that the state gives in lieu of a security deposit. And this has all been brought up through the Supreme Court of Connecticut, and it's very, very clear law. And if you have problems with that, I would suggest, that you could call us and file a complaint. This is a really, really important tool for veterans because there is so much homelessness in veterans, and these type of subsidies are created to try to alleviate the homelessness problem. So I don't know, Michelle, have you ever had a case with a veteran subsidy?
I've not had a VASH case, but I know that obviously Section 8, which is something that you folks may or may not be familiar with, and just regular public housing. So Section 8, very quickly, is a federal program like VASH that is given to people who are income eligible. It's very difficult to get because there's not enough vouchers for the need. In federally, it's a voluntary program, but like Kim said, in Connecticut, all the housing subsidy programs are not voluntary. Landlords are required to accept sources of income that are not derived from employment, as long as the tenant is otherwise eligible to rent the apartment, meaning that you don't have 17 evictions, or a credit score of 200 or something that's really low. I mean, it's on a case-by-case basis. But Section 8 and RAP, which is the rental assistance program, which is the Connecticut funded equivalent of Section 8, are all not voluntary programs in Connecticut. And so if you feel that you have even one of those programs, then you need to call the agency, because those are equally as protected as the VASH vouchers are. So I have already teased this issue, but so reasonable accommodation. So if you have a disability and that is a chronic condition, that's the definition in Connecticut, is a chronic condition, and Kim had alluded to it earlier, something like COVID is going to ultimately have to be determined as to whether that is a chronic condition. And it very likely may be, because there's a lot of people who seem to have a lingering side effects from having the virus. But if you have a chronic condition, and as Kim said, it is an exhaustive list. It is, I get a fair amount of migraine cases. I get migraines too, and I get a fair amount of those cases. Plantar fasciitis, which I had a case a couple of years ago. It's not just, being in a wheelchair for your mobility, or being blind, or being hearing impaired. It is really a vast list. And so I always want people to know to not make those decisions on their own as to whether they are disabled or not, and to call the agency, because we can really help you with that. That's why we're here. We're an administrative agency. Our services are free to be a resource to all of you. So but when people have this chronic condition that's disabling, a disability, they may need reasonable accommodation in order to go to work, or to live in their homes, or access places of public accommodation. So the picture we have here is somebody who's pretty significant disabilities, but is in a work environment. And so it may be that this person needs handicapped parking space for van access, or needs to have accessible bathroom stalls, things that would accommodate his need at work. So how would he go about asking for that? Because while it's very evident that this person is disabled, a lot of people have disabilities that no one can see. And those are really the kind of the most difficult, but those are the cases that are the harder ones, because if you have diabetes, people wouldn't necessarily know you have diabetes unless you decided you were going to announce it when you came through the door. So reasonable accommodation for somebody who has diabetes may look like this. They need to take breaks either to monitor their sugar level and take insulin, or they need to take breaks in order to have more times to eat throughout the day, things that wouldn't necessarily be available to people who didn't have diabetes. And so using that example, if I were a person who had diabetes and I needed extra breaks in order to check my insulin levels and to take insulin if I needed it, I would need to request what we call a reasonable accommodation. And so I would need to ask the person who is likely my supervisor, but employers really should let employees know who that person is to ask. And you should ask that person. Now, ideally, that request would be in writing, but the law doesn't require it. And case law doesn't require your request to be in writing. If you verbally ask your supervisor for an accommodation, you have begun what we call the interactive process. And that is the process for which you, as the employee, and your management, who make the decisions as to what reasonable accommodation is, will determine whether it is in fact reasonable what you're seeking. So once you make that reasonable accommodation request and say, we're going to say extra breaks throughout the day, the management and the supervisor, whomever is making the decision, may ask you for documentation of your need. And so that documentation can come from a treating professional. It does not have to be a medical doctor. A lot of the times it is, but it's somebody who is familiar with your disabling condition and is also familiar with your need for accommodation. And so the employer can ask you for that documentation, and they can reach out to your treating professional about this particular disability and its need, not about your vast medical history, hopefully not too vast. So when you present this to your employer, they have a decision to make, whether granting you this accommodation would be a fundamental alteration of your work, whether it would be reasonable to give you this accommodation. So basically, it's probably very unlikely that a couple extra breaks throughout the day is going to affect one of the aspects of your job so significantly that you are altering your entire job. But that interactive process has to occur in order for the transaction to be lawful. And so that is where a lot of these cases break down, is in that interactive process. Sometimes employers just never respond. That happens a lot. Sometimes employers just say no without any further discussion, which I guess is a very short interactive process. But that's a lot of what we litigate, are this kind of failure to engage in the interactive process. So in our slide, we have a veteran who might have PTSD. And so that would be a reasonable accommodation if what they're asking for is a quiet workspace. Maybe there's a concentration issue. And if you have that space, then you would need to look into providing it for that person. You couldn't, a lot of the times what happens is that people feel they want to know, why does John get to sit in that cube over there and it's very quiet, or they get an office or something that other people generally don't get. It creates disruption at work for sure. And as the employer, you have to be very careful about what you say and how you say it to non-involved work colleagues, because that can get very tricky too, because there could be a retaliation complaint brought if you as the employer decide you're going to, provide a lot of information to people who should not have that information regarding why John is sitting in the private cubicle away from everybody else. So that's a lot of the issue too, is how employers handle reasonable accommodation. You also might have a situation, and certainly this picture would likely be the case, where you would need to have a ramp built, say in a housing environment. Ramps are a very big accommodation request for housing in order to access units. And even to this day, a million years since I've been doing fair housing work, it's still controversial putting a ramp in. People don't like to see it. People don't like the way it looks. It's kind of ridiculous, obviously, because people need it to get into the building, and we're talking about whether it looks nice or not. But these things are why there's so many cases about disability. A lot of people are still working. They're working with disabilities, and they have needs at work. So that's why we get so many cases regarding disability.
So if you want reasonable accommodation, the best thing to do is to just ask. We often say that you should put it in writing so you have some proof that you've requested the accommodation should it not go well for you. Like Michelle said, they can ask you for medical documentation related to the request only. And then they're supposed to engage in the interactive process. So it might be that you ask your landlord for a doorbell because you can't hear the doorbell, and you ask for the Mercedes of doorbells that has 52 different sounds and plays the Star Wars theme, and well, not the Star, a light show or something of that nature. And he might just give you a blinking light. So it doesn't have to be the accommodation you ask for. It just has to be something that's going to work for your disability. We talked about this a little bit, but I just want to talk about it again. We have a lot of people asking for emotional support animals in housing. That's definitely an accommodation that can be granted if you have medical documentation. There has been some people who have decided that they want their pets to live with them in a no pet building and have gone on the internet and gotten fake certificates. And there's definitely not something you want to engage in. If you have a doctor's note or a therapist's note or a nurse's note, all that is fine. And it can be a therapist that you see online. I think most of us are seeing our therapists online these days. But it can't just be someone that you just go on the internet to get a certificate because you want to have your pet live with you. So that's pretty important.
So about 3 years ago, I think it's about 3 years now, the commission worked with students in a clinic at Yale Law School regarding protection for people with bad paper. And May Flexer, who's a senator, really championed it also. There was a lot of people involved with this initiative because veterans or who had not a dishonorable discharge, but not an honorable discharge, they fell somewhere in between, were being denied services. So on a state level, changes were made to our statutes in order to provide services to people who have what's known as bad paper. So they were less than honorably discharged. And the reason it was done is because there was people who were discharged for a variety of reasons that were really beyond their control in terms of maybe the actions they took that got them discharged, and they were related to discrimination. Of people who were sexually assaulted and had PTSD after because the sexual assault occurred while they're in the military, and then translated into a disability that then might have led them to a place where they couldn't perform their function, was all happening because of something that may or may not have been or not adequately addressed while the person was serving. Also for service members, because there's been changes back and forth with sexual orientation status and whether you could serve or not serve, or you were let go because of it. Those are the things that would get you potentially this less than honorable discharge. And then just plain mental health conditions that resulted from service and exposure during service that then led to behavior that led to this less than honorable discharge. And so what the state did, now remember, this is just on the state level, not on the federal level, was change the definitions and the requirements in our statutes to allow veterans who had this bad paper discharge to be able to access stateside services based on some of these protected classes that they fit into. So Yale, I believe, still works on it and still active in it, Yale Law School. And they're obviously an incredible resource in general, but a resource for this too. And if you need assistance with getting benefits because of a discharge of that nature.
So we're coming towards the end, but I just want you to know that it's pretty easy to contact us. You can go on our website, which is www.ct.gov/CHRO, and it will show you which regional office you should contact depending on where the discrimination took place, or where, if it's a housing case, how you contact our housing unit. What will we do if you contact us? We can help you draft a complaint. We can serve the complaint on the respondent. That's whoever discriminated or you allege to have discriminated against you. We'll mediate the complaints. We have a really good success rate in mediating complaints when they come into our agency, and we might be able to get you a settlement before we even investigate. But if we can't settle the case, we'll investigate to determine whether there is a reasonable cause to believe discrimination has taken place. And if we find there is reasonable cause, we'll prosecute that. Most of the time we're prosecuting that in an administrative form in our Office of Public Hearings. In housing cases, sometimes we're prosecuting that in court. That's a really quick and dirty primer of what we do. But if you have questions about what we do, I would definitely say go on the website. There's tons of information.
Stop, Alexa.
Or just call us and let us know.
This is a time check. You got about 15 minutes left,
I think we
Okay,
have
thank
about
you.
5 minutes. Thank you.
Yeah,
or
exactly.
5 minutes, really.
So we have partners, federal partners in the work that we do. We receive contracts from both the U.S. Department of Housing and Urban Development to investigate and litigate our housing discrimination cases. And the same goes for our employment discrimination cases. We have a federal contract with the U.S. Department of Equal Employment and Opportunity Commission, which is these are both the federal equivalents of the work that we do. They too take cases into them in terms of investigation. A lot of the time, especially the U.S. Department of Housing and Urban Development, send the cases to us for investigation. So just as an aside, if you do file a case with us, you may see different numbers, different case numbers than the one we've assigned, and they're likely from the EEOC, which is on an employment case, and HUD, which would be on a housing case.
So I just wanted to mention before we go that there is another law that gives veterans protection against discrimination. That's the USERRA, the Uniform Service Employment and Reemployment Act. And the main issue that they deal with is when you have to go away on leave to serve your country and come back, that there's a guarantee of having your job back. It also has some discrimination aspects to it. If you have an issue with that, you should contact the U.S. Department of Labor. And that is the presentation. I don't know if anyone has any questions, but we do have a few minutes. We've given our phone number here, and there's a toll-free number, TDT number, and our website. And we really have a lot of information on our website if you want to peruse that. I'll also put in a plug that if anyone is an employer in the audience, don't forget you have until January 1st to get your sexual harassment training done. If you don't know what I'm talking about, go on our website. Any parting words, Michelle?
Yeah, I just want people to know that our services are free. An administrative agency like ours is set up to provide service to members of the public for free. And so if you have a question or you're confused about something or you really don't know the answer, we're here to help you out as it relates to discrimination. And so I just encourage people to not try to figure it out on their own, just like I don't figure out how to clean my teeth on my own. I go to the dentist. You too should figure out things that are figure outable to you, but not this kind of stuff, because it's very nuanced. And Kim and I have been doing this for a little bit of time, and every day we still have questions about what we do and what comes along. And so we're really here as a resource to you. The other thing you should know too, just for purposes of our times now, our offices are closed to members of the public. So everything that we do will be online. And you won't notice the difference because we've gotten pretty good at it. But just know that you can't come to our buildings right now because the state buildings are closed to members of the public. So if you do need to reach us, please use the numbers that are provided or our website, which also has email contact information for the 4 regional offices, because we won't be able to see you in our buildings. Those are my parting words of wisdom.
We're sad we couldn't be at our booth and talk to you in person and give away our pens and our whatever else we would have been giving away. But we're happy that we're at least able to interact with you in this virtual way. And I hope everyone stays well and safe.
Okay. All right.
Our presentation.
Yes. Thank you both. I don't know if there's any questions. Doesn't look like it. I learned a lot. So anyway, do you want to just sign off in a little bit?
You can wait let's wait a couple of minutes.
You want to wait a little bit?
Inspired.
Okay.
Hi, ladies. This is Alessia, the director here, Residential Program and Service. I do have a brief question. It says we have a couple of minutes. What have been the types of general complaints that you have been working through as of recently in working with veterans? And I'd be interested in hearing a little bit about that.
Okay. I mean, I think a bulk of the cases that we get from veterans really have to do with disability. And they have to do with service animals and emotional support animals and mental health conditions. That's been my experience, and that is in housing and in employment. And so while what the disability is likely a result of the service, it has to do with those types of protected classes, particularly. That's been my experience. I don't know, Kim, if you have something different.
No, I would agree. It's mostly disability, a lot of PTSD.
Mm-hmm. And then people have service animals as a treatment for the PTSD, and then the service animal becomes an issue, particularly for housing providers.
Yeah, thank you for that. Appreciate it.
Well, thank you for joining us. Take care.
All right, thank you. I'll end the
Thank you.
recording now. Okay.
Great.